Thank you everyone for joining us today. Today we're going to be talking about the right to attend court and preparing the JV 290. I'm Lily and my colleague Summer are from the California Department of Social Services. We're joined today with Jen and Maggie from the California Alliance of Caregivers, Lauren from Advokids, and Jess from Think of Us. Thank you all for joining us today. Next, I'm going to be talking about webinar logistics. In the chat, you should access the transcript link. We are transcribing in real time. Corey is assisting with live transcription services that will be in the chat function. And Corey, if you're able to put it in the chat, if it hasn't already been put there, please help, or I will put it in right after I go over these webinar logistics and introductions. Participants are in listen-only mode and are encouraged to submit questions in the questions section of the webinar toolbar. The webinar will be recorded and emailed after, and handouts can be downloaded today. Right now, you can access them in the handout section of this webinar toolbar. Thank you. Our agenda. We will begin with some introductory announcements. We'll go over the big picture. Lauren from Advokids will cover the juvenile court and preparing the JV 290. And Maggie from CAC will discuss the JV 290 in a deep dive example. Finally, we'll end with a summary and question and answer period. First, Summer, take it away. Looks like Summer was unable to join us again, so I will share information about the FERS Family Urgent Response System. We have an exciting announcement. The California Department of Social Services is excited to announce that the Family Urgent Response System is online. This system provides 24/7 hotline support for caregivers and foster youth. You can call, text, and chat. There's a live website that's available, and providers are available to support in all kinds of urgent response questions. Let's say you're a caregiver and you're stressed out and you need support with a particular issue and you don't know what to do and it's after hours, call and somebody will be available to help you. The contact information is 1-833-939-FERS. Feel free to add that to your cell phone or contacts list. The system has just been launched and you can get more information at the California Department of Social Services website. Next, we have Jess from Think of Us. Please take it away.
Thanks, Lily. I'm excited to be here. Think of Us is partnering with the California Department of Social Services to provide kinship navigator supports across the state. We're currently hiring for community responders, a community responder manager, and a state lead. If you or others you know are interested in joining our team to support kinship families, please go to our website listed here at www.thinkof-us.org/careers to see the job descriptions and apply. We will also keep you all posted about when our website goes live. Thanks, Lily.
Thank you so much, Jess. We are very excited to have Think of Us as our kinship navigator partner. Please be on the lookout for their announcements. And if you know anybody who might be interested, share information that they are hiring. The big picture. So today we're going to talk about the right to attend court. Caregivers have a right under state and federal law to attend court. We're going to be talking about the right to be heard, the right to notice, and how to fill out the JV-290, the caregiver information form, the juvenile court's caregiver information form. We are very fortunate to have Lauren from Advocates as our presenter on how to fill out this form and the background on the child welfare system for caregivers. And then Maggie will do the deep dive example. Lauren, take it away.
Okay, thank you, Lily. So yeah, I'll be talking about communicating with the court and the guidelines for completing and filing a JV-290. As Lily said, I think I'm a staff attorney with Advocates. And for those who are not familiar with us, Advocates is a nonprofit organization that advocates for the child welfare system to provide legal rights and protections to which every California foster child is entitled, including each child's right to safety, security, stability, and timely permanency as required by law. All of our legal services and programs facilitate and support critical intervention on behalf of children in care and children at risk of abuse in California by improving access to the juvenile court, improving the flow of information to the juvenile court, and encouraging system-wide reporting and accountability to promote health and safety for all children in care throughout California, with a special focus on the unique psychological and developmental needs of infants and toddlers in care. The information I'm going to share with you is based on the questions that we get multiple times a day, every day on the 290 on how to fill it out. So it will be detailed, and I'll note responses to some of the questions that come up with some regularity on our Advocates hotline. All right, so just to start with some basic general information about our system as a whole to help better understand the JV-290 and how it fits into the juvenile dependency court context. As many of you may know, the majority of the time, a dependency case comes to court shortly after a child has been removed from their home by the police or a social worker, who may remove a child from their home if they have reason to believe that there is an imminent risk of harm to the child. It's really important to understand that the child is entering a system with inherent tension as a result of the competing foundational principles of child welfare, including family integrity, child safety, the child's need to be raised in a family, the preference for kin care when children can't safely remain in the birth parent's home, the child's need for permanence, respect for cultural heritage, and the rights of parents and children of a certain age and maturity to have a say in the decisions that affect their lives. For decades, the child welfare policy and practice have, child welfare policy and practice have swung back and forth between intense focus on child safety and protection on the one hand, and investments in family preservation and support on the other. So who's in charge? The main participants in the juvenile court process are the juvenile court, the judge, county child welfare agencies, DCFS, biological parents and their attorneys, the children and their attorneys called minors counsel, sometimes a CASA, Indian guardian and or tribe, foster family agencies, and caregivers, both relative and non-relative. And while all of these participants have varying levels of opportunity of voice in the case, the judge is the ultimate decider in juvenile dependency cases. One of the main issues that we see time and time again through our Advocates hotline is that the problems in a child's case are not identified and communicated effectively and or timely to the juvenile court or the responsible agencies. The best outcomes for children in care really occur when everyone involved in the child's care and supervision work together using all of the legal tools available to them. More information from multiple sources allows for informed decision-making by the juvenile court. The court always receives a report from DCFS, that's the county agency report, and the court also can and should, whenever possible, receive reports from the FFA, the CASA, relatives, and the caregivers through the JV-290 Caregiver Information Form, which is the basic vehicle available to all caregivers to access the juvenile court. A caregiver's right to access the court is recognized both in federal and state laws. Foster parents in California have fought to pass legislation to ensure this right to attend review hearings, to file 290s, and to really just play an active role in the juvenile court process. To encourage and facilitate caregiver participation, California law provides that caregivers should have knowledge of their right to receive notice, their right to attend the hearings, and the right to complete the JV 290 caregiver information form. Notice of the time and place of each scheduled review hearing must be served on the caregiver no earlier than 30 days and no later than 15 days before the hearing. The notice must be given on the Judicial Council form, the JV 280. Foster family agencies are required to provide timely notice of the hearing to children's caregivers if a child resides in a foster home certified by an FFA. Again, timely being between 15 and 30 days before the hearing. We don't really often see it provided within the appropriate time frame. The law requires that a written summary of the social worker's recommendations be received by the caregiver at least 10 calendar days before the scheduled hearing. Typically, the recommendations are going to be on the notice, the JV 280 notice. And FYI, for those of you who've never received your notice, the recommendations are typically just a sentence or two. They're not very long. So for example, if you have like an upcoming review hearing, a recommendation might look like no change in the custody status or an existing court-ordered permanent plan for the child. That's a common one. Or it could look like return home to parent, return to home of parent. For a 366.26 selection and implementation hearing, commonly referred to as a TPR hearing, it might be something like termination of parental rights and implementation of a plan of adoption. So pretty short and sweet. California law also requires that the social worker include a copy of the 290 with a summary of his or her recommendations to the caregiver in the caregiver's primary language when available. This is page 1 of the 2-page 290 form. The JV 290 is a simple, user-friendly form that helps you organize detailed information about the child and communicate with the court. The goal is to enable the judge to make informed decisions about the child and reach the best outcome regarding the disposition of the child. It's important to keep in mind that it's considered in conjunction with the views and information provided by the other participants in the case, which can and often are conflicting or contradictory. Along with the JV 290, the county must provide the JV 290 information instructions. To assist caregivers, the Judicial Council created this JV 290 instruction sheet, which provides detailed instructions for filling out and filing the JV 290. If you don't receive a JV 290 and instruction form with your notice, you can find both of these forms on our website or Google them. So notice to the current caregiver of the child must indicate that the person notified may attend all hearings and or may submit any information he or she deems relevant to the court in writing. We recommend filing the 290 as opposed to writing a letter because 1, the 290 is formatted for proper filing and service, which is really important. And 2, it helps the person drafting to stay focused on the information that the court finds helpful in its decisions about the child, which is helpful to you for building credibility and establishing a productive relationship with the court. Before each review hearing, the court must read and consider and state on the record that it has read and considered the report of the social worker, the report of the CASA, the case plan submitted, and any report submitted by the child's caregiver, meaning the JV 290. Courts are recognizing the value of caregiver input through the 290 with increasing frequency. As a resource parent or relative caregiver, you know the most about the child's current circumstances and needs and should provide any information or concerns you may have to the juvenile court. Through the 290, caregivers really offer judges their daily eyes and ears as they provide a home for a child in care. There are 2 keys to always keep in mind with the 290. I must repeat this like 1,000 times a day. So first, it should be child-centered. This form is not to report on parents, it's not to report on extended family or general issues with the agency, it's about the kiddo. As noted previously, that the goal is to enable the judge to make informed decisions about the child. This is the vehicle to share any concerns or individual needs the child may have that are or are not being met. It should also describe the child generally, providing a baseline for any behavioral indicators of stress that may arise in the future. In other words, it should be a balanced and measured communication by noting areas of progress, thriving, and general baseline information in addition to concerns and needs. Second, because 290s build your relationship and credibility with the court, in addition to being child-centered, they really must be factual. Things that you have personally witnessed or independently observed or verified. This really is not always easy to do in such an emotionally charged circumstance. There's a lot of second and third-hand information passed on to caregivers from social workers, from biological parents, extended family, etc. So if it's not something you know to be true, most of the time you should probably not include it unless you can support it. However, sometimes people feel really strongly that they want to include something. If you think it's really critical and it is not, cannot, or will not be shared by the source, then you at least need to qualify the information as an understanding based on XYZ explain why, or you were informed by so-and-so that XYZ. If you aren't sure whether you should include something or how best to frame it, an advocate's hotline attorney can assess with you and provide feedback regarding relevance and language you can use. Sometimes when people really want to include something that's not necessarily responding to the question, we can rework and reframe it so it's more focused about the kiddo, but the concern is still raised. I'll walk through completing the form, starting with the captions, which are the boxes at the top of the page, the court name, street address, and mailing address. I noticed some people this probably seems straightforward or self-explanatory, but we actually get a lot of questions on how to fill this out, and I think people just want to make sure that they're doing it correctly. So for completing the caption, you'll write the name of the county where the court is located and the street and mailing addresses of the court. If you don't know the name and address of the court, look on the notice of the court hearing that you received in the mail. For branch name, you can write juvenile. For the child's name section, you should write the child's first and last names, as well as the hearing date and time where indicated. And if you don't have this information, you can ask your social worker. The case number is on the notice of court hearing that you received in the mail. If you don't have this number, you can ask the social worker or attorney. If the case involves siblings, there may be more than one case number. Be sure to use a separate form and the correct number for each child. On page 1, you'll complete information about the child and about yourself. So for item 1, you'll fill in the child's first and last names, date of birth, and age. Item 2 is completed by resource parents, by relative caregivers, any other individuals caring for the children. You'll include your name, what type of caregiver you are, and how many years and or months the child has lived in your home. Caregivers, you can skip item 3. This one comes up all the time. Item 3 is just for FFAs who also are supposed to be completing this form, and I'll touch on that in a little bit. But if you're a caregiver, you go ahead and skip number 3. Sometimes people kind of partially fill it out. They're not really sure what to do with that. You can just leave it. All right, the user-friendly question format begins at the bottom of page 1 of the 290. The form prompts you for the type of information the court wants to know. Again, it's really important to answer the question asked. This is another reason we suggest doing the 290 versus letters, which tend to veer from the information the court wants to know or needs to make its decisions about the child. So for number 4, current status of the child's health, you can provide information on the child's medical, dental, and general physical and emotional health, such as doctor visits, hospitalizations, and medications. I see that people often skip this section or don't address topics they don't perceive to be problematic. You should be inputting information into every section because it gives a snapshot of the level and quality of care that you're providing to the child. And as I mentioned before, it provides that baseline information for the court. So dental is one that I see skipped over a lot, so I'll just use that as an example. If there's nothing super noteworthy, you can just say, the child sees their pediatric dentist regularly. The last appointment was on such and such date for cleaning or whatever. Child's dental health is good. Next appointment is on such and such date. And this is really good too because you want to show the court that the basic needs are being met. So even if it's not at issue, we still need to note it. Okay, this is sections 5 through 8. 5 wants to know about the current status of the child's education. Here you'll provide information on the child's status at school, such as the child's grade level, public or non-public school, how the child is doing in school, outcomes of testing, or information from school conferences. One of the biggest issues I see here is people say like, oh, my child not in school. You should still complete this section. You can note that the child is not yet school age. You can note that you engage in various age appropriate activities to promote development and learning. For example, might note that you read interactive or sensory books with colors and numbers or animals that make noise. If they can count to 5 or 10 or whatever, they can tell you how old they are. Do they know parts of their body, interest in puzzles? Basically, all the different activities and exercises you do to stimulate their learning and their curiosity, exploration, coordination, creativity, and attention, all of that good stuff. For item 6, you'll indicate whether the child is a special education student, and if so, the date of the most recent individualized education plan. Okay, number 7, this is a big one, the status of the child's adjustment to living arrangement. Here you're going to provide information on how the child is adjusting to your home, such as behavior at home, how the child interacts with other family members, how the child expresses feelings and needs, and the child's eating and sleeping patterns. I see people struggle with this section the most and often default to writing a few statements asserting that the child is bonded, attached, and loved by the family. It's better to provide specific details so that the reader comes to those conclusions on their own. So we want to see how the child interacts in the home environment. Do they share a room? Do they have their own room? Do they know which room is theirs? Do they refer to the home as home? For example, like, when will so-and-so come home, or after the park will we go home? Do they refer to certain rooms as mom's room, sister's rooms, or whatever? Different ways that they show ownership in the home. Maybe the child's toys and books are accessible at levels in a certain room, or how they help out around the house, like putting dirty clothes in the hamper, setting the table, helping with cooking. Explain what their routine looks like, including meals, bath, and sleep, and what do you see when that routine is disrupted? What helps the child to move through those off days? You can talk about what foods they like and don't like, and how you engage them to try healthy new things. Or for some people, bath time's a challenge. What happens in the home to engage the child in a happy and productive bath time? So we're really doing 2 things with number 7. You want to provide pertinent information to the court about the child, really allowing the court to see this child as a unique individual. But this section also really allows the quality and level of care to be inferred through these types of details. 7's important. 8 is the current status of the child's social skills and peer relationships. Here you can provide information on how the child is getting along with others, including their peer relationships, relationships with teachers, and other adults outside of the family. The common thing I see here is just like few word sentence, like child gets along well with others, or child loves the biological children in the home. That one's said a few different ways. It's more helpful to describe the interactions. Are the child's relationships age appropriate? Why or why not? Is the child social? Is the child shy? Do they readily engage with others or prefer to sit back and observe? For younger children, is the child doing parallel play or engaging in play with others, learning to share, struggling with learning to share? For all ages, what success and challenges is this child experiencing with regard to their interactions with others and any respective support that you facilitate or provide? It should also include how the child reacts when around adults they know and around adults they don't know. Maybe they're shy at first, they hide or hold on to you but warm up quickly, or not. Maybe they're terrified around any stranger or particular type of person, and the reactions are really considerable and noteworthy. Sections 9 through 12. 9 wants to know about the child's special interests and activities. Here you can provide information on the child's interests and activities, such as participation in sports or music lessons, how often the child participates, any talents, interests, hobbies. One of the common things I see here is just basic unsupported declarations, something like, child loves music. You, again, want to provide sentences for context to help us understand why you say that. Give examples so the reader is not taking your word for it, but seeing how you objectively come to the conclusions that you do. So, it might be no matter where we are, when the child hears music, they have to stop and start dancing and clapping or break into their cheerleading routine, or they always ask me to play this song. Maybe they just are always running around shouting, I love music. But we want to see that you're not just trying to speak for the child, that it's your involvement and you're paying attention and interacting with this child that allows you to report this information. And that's kind of what helps build the credibility. Section 10, other helpful information. This one kind of operates as a catch-all. So you can provide any additional information that you believe the court should know about the child, such as behavioral information, services the child is receiving, if not mentioned in number 4, or additional details that you didn't include in number 4, your recommendations for additional services that are needed, visitation information, such as dates of visits with parents or siblings using a factual log format. And don't only include negative information. I like to give a general description of the child here because there's not really a question that asks for that, but it also helps us see if certain events are triggering an uncharacteristic behavior or outcome from the child that doesn't follow kind of their typical nature. And that kind of helps us track whether something is problematic or not. What I often see in number 10 is caregivers sometimes want to report on the visitations and the traumatic or the behavioral indicators of stress, kind of indicating that there's trauma from these visits. And so they'll just say like, oh, after the visit, the child has trouble sleeping and they're really clingy, whatever the behavioral indicators of stress are. But we don't know if this is a child who commonly acts like that or not. So you want to start out saying, Jane typically is a very happy social kiddo who loves to engage in any activity she's exposed to. And then we know, when you note those other reactions, that we're seeing something uncharacteristic for Jane. Okay, number 11. In my experience, this section really throws off caregivers who will either leave it blank out of fear or confusion, or they go too far in the other direction, telling the court to terminate parental rights and order the child adopted by them. I always recommend completing this item with measured language that communicates the important information to the court, but also demonstrates your understanding that there is court process and procedure that must be followed in these cases. What you actually write in this section may vary depending on the facts, but for most 290s, I actually have some boilerplate language, which is, we respectfully recommend maintaining the child's current placement, routine, services if applicable, and relationships, so important, to support the child's interest in stability and continuity while the case is ongoing. If the child is unable to reunify for any reason, we're committed to providing permanency for the child through adoption. And this type of statement works because it's child-centered, it's stating your recommendations based on the child's interests and needs, it demonstrates an understanding of process and roles, it doesn't undermine reunification, and it still communicates your commitment to permanency, assuming that's the case, for concurrent planning purposes. It's really important that the court know that you're committed to providing permanency. The trick is communicating that without appearing like you are also undermining reunification or without putting yourself at risk of being accused of undermining reunification. Item 12, if you have attachments, be sure to check the box on item 12. Indicate the total number of pages attached and include the date and the case number. And finally, the signature and date on the bottom. Write the date, type or print your name, and sign where indicated. The biggest thing I want to note here is I often see, even when there's more than one resource parent, if there's like a couple, if one person's completing this form, sometimes it just has the one parent's name on page 1, and then on this page, just the one parent's name printed and signed. It should have both resource parents on it if there is more than one. Okay, so you should document all contacts with the child's attorney, keep a log and document frequency of visits. If you've had trouble regarding contact with the child's attorney, you can note that in number 10 as well. Just keep in mind that all parties receive a copy of your 290, so it's really helpful to stay factual and always be respectful even when reporting a problem. So what I mean by that is there's often lots of information that caregivers aren't aware of. So just in your communications, it shouldn't appear that you're speculating as to reasons you haven't received contact or anything that might be going on. You would just factually note the attempts you've made to reach out and that you've yet to have a response, but kind of without the throwing someone under the bus sort of tone. It's likely that you'll not be able to fit everything on the form. If and when you need more space, you can note continued on attachment 1 for each section on the form that you need more space for. All overflow goes on the same attachment, attachment 1. You can label each attachment page and distinguish which section you're continuing by using a heading with the number and the title of that section. So this is a format that I use for attachments. Anything similar to this would be good. The idea is to keep it organized for the court so they can follow along like a kind of like a map of the information you're providing. We encourage caregivers to reach out to medical providers to advocate for the child's mental and physical health. If there are specific medical, dental, physical, educational, or emotional issues addressed in your report, ask your child's doctors, ask the teachers, the daycare providers, whomever the other professionals in the child's life are, to write a letter of support. And whenever possible, you want to attach these support letters to support your concerns for requests for services. Remember that the court does not know you. The caregiver doesn't have the same frequency of interaction with the court as the other participants in the case, so you have the toughest job of building that rapport and credibility. On our website, we have a sample request for medical services letter that you can use to contact pediatricians, mental health professionals, and any other providers who treat the child. It's basically a letter that allows you to open the conversation and provide specific behavioral indicators of stress that you're seeing, and to start that conversation with the provider to see if maybe they would agree that they're seeing the same things and provide a letter of support to the court, maybe with directives, referrals, or recommendations. General content, this is just a list of kind of general things to keep in mind. You may want to attach a picture so the judge can put a beautiful smiling face, the name, and file number. The court has so many cases, so providing a picture can help the court to see this child as an individual with unique strengths and needs. I get a lot of formatting questions about this. Typically, a single page with 3 to 5 photocopied pictures is sufficient. We're not looking for a photo album here. It is okay, and in my opinion, a good idea to have pictures of the child with your family, but you should also just have some single pictures of just the kiddo. Again, you want to report all the positive developments in the child's life and progress made in addition to concerns and behavioral issues. So think balance. The JV-290 form may be submitted in connection with court review hearings, which are held every 6 months after the disposition hearing, starting with the 6-month review hearing. I often get the question, I filed the 290 for our last hearing, am I allowed to file it again? The answer is a resounding yes. You can and should file a 290 for every review hearing in the case, including continued hearings. You should file 290s faithfully and consistently prior to every review hearing, starting with that 6-month review hearing. Down the road, if you need to solicit assistance from the juvenile court regarding your child, your 290 forms will help the judge to track your participation in review hearings and will show how hard you've worked on the behalf of the child in your care. The 6-month review hearing is set within 6 calendar months of the disposition hearing and must take place within 6 months after the disposition hearing and no later than 12 months after the date that the child entered foster care. When at the 6-month review hearing, the juvenile court orders continued provision of reunification services, it must set the case for further review. This hearing, known as the 12-month review hearing or the permanency hearing, must be held within 12 months after the date on which the child entered foster care, which is from the date of the jurisdictional hearing, or 60 days from the date of removal, whichever is earlier, but in no event later than 18 months from the initial removal. In most instances, the last possible review hearing before the court establishes a permanent plan for the child is the 18-month permanency review hearing. An exception does exist with respect to a parent who shows promise in a substance abuse program or who has been recently discharged from incarceration or institutionalization, in which case a 24-month review applies. 24-month review would also apply if the parent was a minor parent or a non-minor dependent parent at the time of the initial review. Be sure to file your 290 within the required time period. If you choose to file the form in person, the rule is at least 5 calendar days before the hearing. You would bring the original form and the requisite amount of copies to the court clerk's office at the courthouse where the hearings are held. Ask the clerk to file the form for you. You should always keep 1 copy of the date stamped form for yourself. And during COVID, many courthouses have drop boxes outside the courthouse and more are offering e-filing. We're hearing a lot of good feedback with the e-filing counties. If you choose to file by mail, the rule is at least 7 days before the hearing date. You would mail the original form and all but one of the copies that you keep for yourself to the court clerk's office at the courthouse where the hearings are held. You should include a cover letter indicating for filing and service and including the case number. We have these filing instructions and a template cover letter that you can use on our website. Regardless of the 5 in-person rule or 7 by mail rule, at Advocates we usually suggest 2 weeks. File your forms 2 weeks before the hearing just to give a bit of a buffer. And it's important to note that the clerk is responsible for providing the form to all parties and completing and filing the proof of service form. So all you have to do is complete it and submit it. So Welfare and Institutions Code 366.21D actually requires FFAs to submit a report on the 290 if they want, before a status review hearing or a 366.26 implementation of permanent plan hearing. Most FFAs are unaware that the law requires this and often just provide a report directly to the agency. While that's totally appropriate, they should also be filing their own report directly with the court, and that can be done on the 290. If you're a caregiver licensed through an FFA, consider reaching out to your FFA caseworker regarding whether the FFA will file the 290 form or report with the court before the hearing. As provided on the 290 form instructions that you see here, caregivers with FFAs are allowed and encouraged to independently submit their 290 information report to the court in addition to any reports submitted by the FFA. So even if your FFA does file the 290, you should be filing one as well. And you shouldn't worry about overlap. If your information is similar to the FFA's information and similar to the social worker report information, that's really good for the court. That means the court can really count on the information that this is what's going on in the case. If there are some significant differences between the information being provided, then that alerts the court that there might be some confusion, misunderstanding, or a problem that needs to be addressed. So it's really important that the court's getting information from all people in the child's life. And I just want to note that the instructions also encourage confidential resource parents to provide the information to the social worker. However, I would only recommend that you do this, meaning that you give your 290 to a social worker as opposed to filing it yourself. I always recommend you file it yourself unless it's just absolutely necessary that you have to give to the social worker, because filing your own 290 allows you to keep control over what information gets to the court, and it allows you to maintain better records. There are other ways to protect your information, like using initials or writing resource parent instead of your actual name, and or filing a JV 287 confidentiality form to attempt to keep contact information private. I will just note a little caveat on confidentiality. There is no guarantee with confidentiality. Human error happens all the time, and sometimes someone says the information out loud in court or it doesn't get redacted from a form. Once that happens, there is no way to take the information back, and there is no recourse for the error. You should still do what you need to do to try to keep your information confidential, but just be aware that there's no guarantee. So just a little information about Advocates legal programs and services. Advocates is a resource available to all of you to promote the well-being of children in care in California, to try to protect them from further additional traumas that are often inflicted while they're in the child welfare system. We operate a number of different statewide programs, including the only free telephone hotline providing child welfare law information for anyone concerned about a child in foster care in California. We get calls from everyone on the child welfare system spectrum, from caregivers, from social workers, from minors councils, from FFAs, physicians, therapists, CASAs, everybody. We also operate a children's attorney consultation line to assist with identifying persuasive legal arguments and strategies for promoting the child's best interests and improving outcomes for foster children. And we have a very comprehensive interactive website for the general community and child welfare professionals. We also have some state bar approved MCLE programs on child welfare law issues and educational programs for social workers, foster parents, and other caregivers and mental health professionals, also FFAs and CASAs. and any other child welfare advocates on child welfare law, the social science and neuroscience research on child development, and how this research should inform the court's decision in child welfare cases. This is my email and advocate's number and website. If you have any questions, specific questions about a particular case, I invite you to give us a call. Each case is different, so we would be happy to discuss the details of your case with you, what your concerns are, and what options might be available to you in terms of accessing and communicating with the court. Thank you. I think, Jen, are you gonna introduce Maggie?
Sure. Hi, this is Jen Rexroad with California Alliance of Caregivers. Thank you to everyone who is joining today and learning about how you can submit information about your child to court. California Alliance of Caregivers is a statewide organization that represents the voice of relative and non-relative caregivers to promote the well-being of children in foster care. And we have a statewide coalition of foster and kinship parent leaders, including Maggie Diverd from Stanislaus County. She's a lead resource family liaison, and she is joining us today to go over kind of the practical pieces of completing the JV 290. So here is Maggie.
Thanks for the intro, Jen, and thank you, Lauren, for the thorough explanation on the information the court is looking to see from caregivers. So like Jen said, my name is Maggie Diverd. I was a resource parent in Stanislaus County for 6.5 years. For the last 5 years, I have been a resource parent mentor. I assist families in navigating the child welfare system in our county, explaining the foster care process, and helping to support and encourage families in uncertain times. Our program also assists families in completing de facto parent paperwork and JV 290s. So filling out a JV 290 caregiver form helps to give more context to what the day-to-day life of a child looks like. As a caregiver 6.5 years ago, I didn't do this form and I wasn't aware of it. I just assumed that the social worker would be completing and explaining this to the court. And so I was inexperienced. So I'm very thankful that I'm now in a position where I can let caregivers know that they should be completing these forms and that they are able to. So for this exercise, I am going to be using Jane, a 7-year-old first grader who has been in foster care for 8 months. She's been in my home for 7 months. Her mother has open reunification services and is engaged in visits with Jane, but her father has services but is not actively participating in visits. She's well adjusted to my home but struggles with changes to routines. She's outgoing in familiar settings but becomes more timid and standoffish when she encounters new people. Okay, so as Lauren mentioned, you can Google this form. It's also available on, there's going to be a link in the handout, or you can go to Advocates. And I would start typing out my county, Stanislaus, and the address to our court. And when you're done, it would look like this. Our county, the street address, mailing address, the city and zip code, the branch name, and then the child's name, the hearing date and time, and the case number, which, as was mentioned, you can find on the JV 280 form that you would receive with a recommendation on the next court hearing. Next, you would click on number 1, and you would type in the child's name and the date of birth and the age of the child. I would advise against hitting tab as I just did because it actually flows to different boxes. So you clicking through is most handy. So the next thing I would do is put in my caregiver information form, and you would contact your juvenile dependency county court clerk to find out exactly how they have it. At our in our county, they prefer initials for the caregivers to maintain confidentiality. and then I would select the type of caregiver. If you're more than one type of caregiver, if you're a relative and also considered a foster parent, you may select both. The tendency is to want to select the pre-adoptive parent box if you are a concurrent home, but you should refrain from doing this unless you are post termination of services for parents. This should only be clicked after that, even though you are a concurrent home. You would also include how long the child has lived in the home. And as I stated, Jane has lived in my home for 7 months. We would skip number 3 because I am a resource parent home and not an agency. And then we would go to number 4, the current status of the child's medical, dental, and general physical and emotional health. So for this example, I would click there is new additional information since the last court hearing. Jane is doing well health-wise since the last court hearing. She had a yearly physical on January 5th and the doctor had no concerns. Her dentist appointment on December 15th revealed that she had 4 new cavities. The dentist advised waiting for treatment until her next appointment to see if there's any new growth. Behaviorally, Jane is thriving in her friendships, typo there, in her friendships and family life. Then we would go to number 5, the current status of the child's education. And Jane is in the 1st grade in the public school system. She received a progress report for the 1st trimester ending October 23rd. She is at grade level for reading and progressing in math skills. The teacher identified that she needs extra support in math. With the help of the education liaison, we were able to start virtual math tutoring for the next 3 months. In the past, I've had this form pre-fill in based on the above info, but if it doesn't do that, you can just, when you print it out and sign it, you would just include the child's name and the case number then printed. So for this example, the child is not a special education student. So then we go to number 7, which, as Lauren mentioned, is the one that contains the most information in the day-to-day life of the child. So we would select B, and then I am going to open a Word document where I have that information listed. So Jane was originally placed in our home on October 13th. Upon placement, Jane showed increased aggression and emotional dysregulation. She is now exhibiting developmentally appropriate behaviors and emotional regulation in line with her age. Jane shows ownership of her home, asking about going home when we are out. Additionally, she talks about how Chandler and Coco, her cats, are home waiting for her. She regularly says Jane's house, Maggie's house, Matt's house in reference to the home. If one resource parent is not at home and Jane asks about their whereabouts and is very excited when they return. When going on parental visits, Jane describes that she is going to play with her mom at the park and then come back to her home. Jane has her own room and bed and often talks about her room and toys. She keeps her toys in an open shelf and will move independently between spaces in the home to get her toys and move them from her bedroom to the living room. Her current favorite toys are her little critter books, her bicycle, and her Barbie airplane. She is affectionate with her foster parents and foster brother. Jane is very happy to see us when we pick her up from school, loves hugs and kisses, says I love you regularly, and values her daily routine. She wakes up between 6:30 and 7 and she wants to cuddle. She likes to play peekaboo with her foster brother, make him laugh. When we get out of bed, Jane will ask to help get dressed so she can feed the cats with Matt, her foster dad. After she feeds the cats, she likes to help make breakfast. And then after eating breakfast, she gets herself ready for school. And she likes to pick out her own clothing and to wear a matching mask for school. During the week, she's excited to go to school when the alarm goes off. We drive together to school at 8 a.m. When we arrive to the school, she gives both of us hugs and kisses, as well as her foster brother. We say, "See you soon, I love you," and Jay responds with, "I love you too." Jane is picked up from school at 3:15. She is excited to see us. She waves and runs to the gate. She gives everyone a kiss hello and tells us about her day, focusing mostly on playing with her peers and trying to master the monkey bars. When we return to the house, she runs out inside to say hello to the cats and wash her hands. She often wants to play in the yard, riding her bike, or playing on the swing set until dinner time, around 5 p.m. Jane is not the most adventurous eater, but she will follow the 3-bite rule for new foods we regularly introduce. Her favorites are pancakes, chicken nuggets, pasta with pesto, and veggies, strawberries, and yogurt. At 6 o'clock, she takes a bath. She enjoys taking baths with bubbles and bath bombs. She is practicing washing her own body. When she gets out of the bath, she puts on lotion and lets her foster parents comb her hair. We then start at 6:30. We read together for 30 to 45 minutes. She likes to cuddle before falling asleep, but falls asleep independently after 5 minutes of back rubs and wishing each other good dreams. On the weekends, she helps to make breakfast. We go to a walk. We go on a trail near our home for her to ride her bike and to get a cake pop from the coffee shop. She will talk about our weekend plans during the week and wakes up announcing where we are going that day. On the weekend, we have quiet time in her room from 2 to 3 o'clock in the evening, and the evening routine is similar to the weekday routine. Jane does well in her routine, but is not flexible when it changes. She does prepare for activities like school or planned outings and is upset when unable to participate. When her routine is disrupted, Jane struggles to regulate her emotions and will cry more easily and more frequently. She becomes hyperactive and wants more attention from her foster family. And on number 8, the current status of the child's social skills and peer relationships. So Jane has a very outgoing personality when she's among people she is comfortable with. When she's around new people, it takes her a while to come out of her shell. She will stick closely to her foster mom, Maggie, and often turn her head and talk into her shoulder when asked questions. She has made many new friends this year. Her best friend, Abby, is in her class. Jane struggles to play well in a group of friends. She is very good at taking turns and changing activities when she is playing one-on-one with children. When she's in a group setting, she feels left out and cannot take social cues to know she is included. When this happens, she will become frustrated and say that she no longer wants to be friends with them and calls them stupid. We are working to help her understand that just because there are more children, she is still included and that we need to work on not calling people names. She enjoys play dates at the park. Number 9, current status of the child's special interests and activities. Jane enjoys watching soccer matches with her foster dad, Matt. She asks to look up soccer videos on YouTube to learn how to do tricks like she sees on TV. There's a local soccer clinic that starts in April that we registered her for. It meets 2 times a week for 6 weeks and focuses on conditioning and learning the basics. Our goal would be to register her for a soccer league when registration opens in May for the fall of the 2021 season. Number 10, other helpful information. Jane did not qualify for wraparound services at her mental health assessment. While she did not meet this criteria, it is still important that Jane receives therapy to help her with the trauma she experienced being separated from her parents. She looks forward to her weekly visits with her biological mother. After the visits, she has difficulty sleeping and exhibits anger toward regular routines that she normally enjoys, like taking baths and reading books. Jane will throw the books and state that she hates reading and that all the books are dumb and boring after picking the ones that are her favorites. She will talk about how she misses her father, who has not appeared for any visits since she has lived with us. We have informed Jane's attorney on January 3rd and asked for a referral from Jane's social worker to see a therapist. When we spoke to the social worker at her monthly visit on January 17th, she informed us that she would follow up on the request. Number 11, recommendation for disposition outcome. We respectfully recommend maintaining Jane's current placement, routine services, and relationships to support her interest in stability and continuity while her case is ongoing. At this time, we are also suggesting therapy to support Jane's emotional well-being during this uncertain time. If Jane is unable to reunify with her biological parents for any reason, we are committed to providing permanency for Jane through adoption. So on the actual JV 290 form, I did include to see attachment number 1 under number 7, because that was going to flow into more space than what was provided. And the same thing for number 8 and number 9, 10, and 11. I selected the box number 12 to say that there were additional sections to this form, and the number of attachments is 2. Pages attached are 2. I include you would put the date here, so today's date. And then the name. And again, like I said, in our county specifically, they use initials, but I did put first name here since that was included in the example under number 7. And then I would print this and both caregivers would sign. Okay, and Lily, I will turn it over to you.
Thank you so much, Maggie. You're not able to see the chat or the questions while you're presenting, but so many people really loved your deep dive examples and really appreciated just how detailed it was and how an explanation of the facts and the details of your specific child could be presented. So thank you very much for all the hard work you did creating this example based on caregivers that you've worked with. It's very much appreciated. Multiple positive comments to that effect have been sent in. So I would like to see if I can pull up the PowerPoint again. And if I have any troubles, I'll ask Lauren to share it. So just bear with me one moment while I try one more time and see if I am able to share my PowerPoint. I have the PowerPoint up, as you can see, and I'm trying to play from the current slide. Okay, can everyone read that okay? If it's cut off, I apologize. Today, I'm very excited that we were able to talk about many important concepts regarding caregivers and the courts. You heard that caregivers have a right to attend court and to be heard. This is both under state law and under federal law. The citations are provided in the PowerPoint, and you can download this PowerPoint by going to the handout section. 15 days before a hearing, caregivers have the right to notice in writing about when the court hearing will be and where. And 10 days before the hearing, they have a right to a written summary from the social worker of their recommendations. You heard a number of points about how to fill out the JV 290. There's no way I can summarize everything that was covered by Lauren and Maggie, but some important things you should know are that the form is available on the court's website. This is an opportunity to share facts about the child in your care. You can submit this JV 290 by making 8 copies and keeping the original, or it might be possible, you can see if it's possible to e-file in your jurisdiction. Yes, it's okay to include family photos or letters from providers. Today, you also heard announcements about a couple of exciting updates from the California Department of Social Services. The Family Urgent Response System is live now. Please take out your cell phones or write this down, the phone number and the website for the FERS program. If you are a caregiver in need of support, or you work with caregivers in need of support, please share this call and text number, and you can get more information about the FERS program from our website. You also heard from Jess from Think of Us that they are a new Kinship Navigator Services partner. You will be hearing more announcements at later webinars about what is available for kinship families in California, and we'll be sharing the new website when it launches. In the meantime, if you or anyone you know is interested in joining the Think of Us team and being part of this Kinship Navigator support system, you can log on to thinkofus.org/careers and find out about applying for job opportunities. We shared some key resources. Most notably, we had on the line today Lauren, who is an attorney who works at Advocates. If you have particular questions about your examples, we obviously won't have time to go over everybody's questions, and we especially can't go over confidential questions during this webinar, but you can reach out to Advocates and their number. You can save that in your phone and share with other caregivers, and you can save their website. You also heard from Jen Rexroad of the California Alliance of Caregivers and Maggie, who is an ambassador working directly with caregivers locally. And you can learn more about supports, advocacy, and services at the California Alliance of Caregivers website, caregivers.org. Additional resources. The Juvenile Council has put together an entire handbook for caregivers on how to navigate the dependency court system. The primer is available at this website. If you download the handouts, you can click on this link and get the full PDF. Additionally, you can download the caregiver information form on the court's website or the relative information form that can be used by families, members, friends, and tribal members as well. I am Lily Colby, and my colleague Summer were also on the line today, and our unit at the California Department of Social Services is called the Foster Caregiver Policy and Support Unit. If you have questions about policies and programs, you can reach our team at kinship.care@dss.ca.gov or by calling us. Okay, now it's time for question and answers. And I have a few questions already lined up. And individuals can add extra Q&A questions in the questions toolbar. We've gotten tons of questions, and I hope to get through as many as possible in the time remaining. First and foremost, I have a few questions for Lauren about the JV 290 and tips for caregivers. My first question is, if you're a relative caregiver, do you use the JV 285, which is the relative form, or the JV 290, which is the caregiver form, or both?
So you can use either one. One of the big differences between the 285 and the 290 is that JV 285 can be submitted at any time during a court case by a relative. The 290 is expected to be submitted just before a hearing because it's considered in the context of whatever decisions the court is making about the child. I recommend that relative caregivers use the 290, however, because it allows you to provide more information about what's going on with the child. And the other thing is, even though you can submit a 285 anytime, if you don't have a hearing anywhere near when you're submitting it, it kind of goes into a black hole into the file and probably won't be reviewed at the next hearing date. It'll just become part of the case file. But it is up to the relative which one they want to file.
Thank you so much. The next question is, do you have any quick tips for preparing for court. In addition to filling out the JV 290, caregivers can be a little bit nervous about it. Can they reach out to your team if they have questions? And if they did reach out to your team, are there any pieces of advice that you generally share with caregivers who've never been to court before?
I mean, I think it kind of depends. Usually when people call in, we talk to them about the circumstances, the dynamics in their case, how are the relationships with the other participants in the case between them and the caregiver. But I do understand it is intimidating to go into court for the first time. Also, a lot of caregivers are discouraged from going to court despite the fact that they have the right to attend. And it can be hard to actually get in the door. Or with COVID, some people are having trouble either getting the link to participate in the virtual hearing, or for some reason it's not working. So it can be a struggle, but generally if people call and after we figure out what the relationships are, we just talk about ways when they get there, how they check in, how they say who they are. If there is someone where their relationship is really good with like the social worker or the attorney, we would probably talk about ways to kind of meet up with them or touch base with them so that person knows that the caregiver is there, and if they haven't been allowed in the courtroom, they can speak up. But yeah, so I mean, it depends a little bit, but those are kind of the things that we go over before going to court.
Thank you. That actually answers the next question, and I'll say a little bit more about it. I'm a caregiver and I haven't gotten notice for court hearings. What should I do? And the answer to that question is reach out to your child welfare department, work with your social worker. You can feel free to download the resources today if you have any questions about that. But you can also reach out to advocates or to the California Department of Social Services Foster Caregiver Policy and Support Unit. And our contact information, advocates and our department's contact information are available. We highly recommend you work directly with your social worker to make sure that you have the information you need. But if you have follow-up questions or you're having difficulty with this, we are available to help.
Lily, can I make a quick comment on that one too?
Yeah.
So on Advocate's website, we have a page called Caregiver Information in the JV 290. And there we list the law of all the information that you should have as stated in the Welfare and Institutions Code, along with links to the authority, the actual Welfare and Institutions Code section. So when people call us saying they haven't gotten notice, we suggest that they reach out to the social worker, always in a, polite tone, but provide the authority saying, hey, it's my understanding that I'm supposed to get notice, I haven't received it, but attach the authority there so the social worker understands where your question is coming from. And we've seen a lot of success with that in resulting in better notice.
Thank you. That helps a lot. And if you have a moment to type into the chat the link to that page, perhaps the individual who asked this question will be able to take down that exact link. And if not, everybody should be aware that the Advocates website has a wealth of information on a number of topics for caregivers, and you can find the answer to that question as well as many others on their website. And our Department of Social Services website has also been shared, and we have a wealth of information on our website. Next question. What forms would I use for a de facto parent if the child is not currently in my care?
Okay, so this isn't a webinar on de facto, and I want to say that the question probably warrants much more discussion. I'll just say that it is possible sometimes for people who formerly cared for the child to get de facto, but generally it's for the person providing the day-to-day care. We have a de facto page on our website, and if you want to discuss your particular circumstances, please do call us. But if you want to know specifically the forms, it's the JV 295, JV 296, and JV 297 forms are on our website, along with information about de facto. But anytime someone has a question about de facto, it usually requires a more in-depth conversation because it's kind of a tricky designation. It's not a statutory designation. It was created in case law, and there are some kind of funky things with it. So please give us a call if you want to discuss further.
Thanks so much. There's been a question about being able to waive your right to get notice. Sometimes in court, it's mentioned, do you want to waive your right to notice? And attorneys reply, yes. Does this affect the ability for caregivers to get notice of hearings?
No.
Thank you. Somebody asked about getting a copy of the slides. We will be sending out a follow-up email with the example that Maggie did today, as well as the full slides that Lauren shared today and the handouts. But we'd recommend that you download any handouts from the webinar toolbar if you are able to access them. We have 4 handouts on that webinar toolbar, but we will also send a follow-up email next week with handouts and resources. A question about caregiver support generally. This question is either for Jen or for Maggie. I'm a new caregiver and I'd like to find community with other caregivers. How can I go about doing that?
This is Jen. California Alliance of Caregivers offers a weekly Coffee with Caregivers online virtual facilitated support group. That's every Friday from 11:30 to 12:30, and it's on our Facebook page, the link to that, and on our website. If you go to cacaregivers.org/coffee, and we have a leadership coalition that you may become a part of, and just find other support groups throughout the state. Many offer various online or other types of support groups. And I know, for example, Maggie's in Stanislaus County, they do a local Coffee with Caregivers, and there are many locally operated support groups to connect with local caregivers.
Thank you so much, Jen, for being here today and for partnering on this webinar series. The California Alliance of Caregivers, in addition to providing that direct hands-on support to caregivers and community with caregivers, has also partnered with us on this webinar series, sharing the key questions that caregivers bring to them, so that way we can answer those questions more broadly and anonymously. So caregivers bring questions to them and we answer them in these webinars. The next question is for Lauren. What is the difference between when a social worker has to provide a summary and when the social worker has to provide minute orders? What is the difference between the summary and the minute orders? And are caregivers ever entitled to minute orders?
Sure. So a minute order is basically like if you have a meeting and someone takes down the minutes of what happened during any meeting, that's what a minute order is. What happened in court, who was there, what were the orders made, when are you coming back to court, and what for. Caregivers are not entitled to minute orders. They're part of the case file. If you're a de facto parent, you can get minute orders from the point that you were designated de facto forward. Doesn't trigger retroactive receipt of minute orders. Then the difference is the summary of recommendations is the 1 to 2 sentences I described on your notice of hearing. So when you have a review hearing, the agency provides a report to the court along with what they're recommending. The court will hear from the other participants and they may accept the recommendation of the social worker or not. So what the notice is providing you is what the agency is proposing for the court's consideration in relation to that hearing.
That relates. Thank you very much, Lauren. That relates to the next question. One of the questions is, how do you find out the status of the case? Like where you're at in the process as a caregiver?
So you should know that from your notice of hearings, but I'm well aware that not everyone gets the required notice. You should ask your social worker, and same thing that I was saying before, from our caregiver information and 290 page, you can find the authority for that. And it's also in the slides, I think. And in a very nice email, just let them know you haven't received your notice. Entitlement to notice for hearings starts at the 6-month review. So sometimes people are expecting it too soon, or sometimes if we hear from people who aren't the caregivers who are expecting notice, like a relative, and those people are not entitled to notice. So the first thing is, to make sure I guess your question is you don't know where you are in the case. So you can ask the social worker, or you can ask the child's attorney to find out where you are in the case, and hopefully you should be informed of the stage by the notice.
The next question is a technical question. When filling out the JV290, sometimes there's information that's missing, like a caregiver's name, or there's something that's already been put onto the form pre-filled when given to a caregiver that's incorrect. What advice do you have for fixing technical errors or adding a caregiver's name, like if there's 2 parents and only one is listed? Do you have any advice for adjusting a form in these technical situations?
Yeah, white out, or you can write in the name, or you can download the JV290 form from Google, our website, and do your own. I think you're supposed, I can't remember if it says blank in the actual statute, I'll have to look at that, but I believe you're supposed to get a blank 290 form. I'm assuming it's an effort to be helpful to pre-fill it. So you could either let the social worker know that there's an error and can they provide you one with the correct pre-filled information, or for next time, but you can go ahead and change it, either writing it or doing your own separate one.
There were a couple of questions about how to remain confidential, and it seems like this might have been a particularly tricky area of your presentation. Lauren, do you want to just say a couple words on that and how they can get additional support if they have more detailed questions about the confidentiality?
Yeah, I mean, it's not that tricky. There's confidential forms. The JV287 can be used with de facto, with the 290, and with the JV285. That's what it was drafted for. And it's to have your contact information remain confidential, like phone and address. So you fill out that form along with whatever form you're submitting, and it's part of the packet that you submit. I think what I was noting is a caveat that completing this form cannot guarantee confidentiality. So when you file any form with the court, it's served on all the parties. What the confidential forms were meant to do is say that this form with the private information on it can only be viewed by, I think it says the court, the agency, and minor's attorney or something like that. So then on the actual form, you just write, where it asks for your address or number, you would write like confidential or confidential resource parent or whatever. So the idea is they wouldn't see the confidential form that's only to be viewed by certain people. For the JV180, which we didn't talk about here, there's a separate one, JV182, but it's the same idea. These are just pre-drafted forms specifically for the purpose of keeping your contact information confidential. And then another common practice is to use initials instead of your name if you wanted to keep that confidential, or I've seen people write resource parent instead of their name. So, I mean, there are different ways to try. The point is there's just no real guarantee, but if you'd like to keep that confidential, those are the different ways that you can do it. And of course, if that's unclear or you have additional questions, please do reach out to us. Happy to discuss further.
Thank you. There's been a number of questions that have come in towards the end. So I'm going to try to cover as many as I can before we end the webinar. But if we do not get to answer your question, please do feel free to reach out to advocates or us at the California Department of Social Services. A number of people have chimed in thanking Maggie for the detailed explanations. Maggie, do you mind sharing just a little bit more about how you were able to put that answer together and your own kind of feelings as a provider and caregiver in this field about kind of advice on how you navigated this, either from a provider perspective or from a caregiver perspective, whichever you feel comfortable?
This a specific example?
Either this specific example or in general, how you approached preparing for court and attending court as a caregiver or as somebody who supports caregivers.
Yes. Okay. So I will say that as a resource parent, it was incredibly challenging to attend court because I did not know what to expect. So when someone earlier was asking about community and things too, I started to make friends with people in the visitation room when my children were going for visits, and I would just really grasp onto people who were ahead of me in the process so that I could ask questions and know exactly what to expect. The example that I have here came with a lot of guidance from Lauren and her example. The example that I had originally prepared was based on how our court here has preferred to see information. So this level of detail was more from Lauren than from me, I will say. But a lot of what we tell our families when we're helping them is really to stick to factual information. This form is not to have a lot of emotion in it. I know that the tendency would be to want to put that because you want the court to know how much you care for the child, but you can easily do that as well by sticking to the facts to show how you are taking care of the child. The de facto parent paperwork is more where we personally have told our families that's really where you can more talk about the day-to-day, like how much you care for the child, what exactly you're doing. But this one is really factual. And as Lauren said in her presentation too, some of our caregivers want to, on the recommendation, put terminate parental rights and we will adopt them. And that really, as she said, it does undermine reunification and in foster care, the goal is reunification. We know that that's not always the outcome, and that is not always what is best for the child because of how the case progresses. But that is what our role is. So kind of reminding ourselves about that as well. So with this example, part of it was my own personal experience with my children in terms of their the age, the range, those things. So again, really sticking to factual information and trying to remove the emotion from it, because that, like Lauren said, that is exactly what the court is looking for.
Thank you so much. Yes. I think the most common question and comment today has been just how thankful everyone is about the detailed explanation you gave. And everybody is asking for a copy of it. We will be sending that out in our follow-up email next week. So keep your eyes peeled for our follow-up email with all the resources. Thank you again, Maggie, for going over that in detail. My last question for Lauren is, can a caregiver be told that they're not invited to attend court, either because the youth, the parent, the county, or some party or some attorney has requested that they not be there?
I mean, people are told that all the time. They have the right to attend. Where you might be asked to leave is often like a biological parent's attorney might say, we're about to discuss private or confidential information of the parent. Court asks the judge to clear the courtroom of anyone who's not a party to the case, and the judge can do that. The judge, is in charge of their courtroom, and so they can ask people to leave for that reason. But I do hear a lot about people being discouraged or told they don't need to come, or they're not to come to court. And in those circumstances, I don't believe that that's based in any sort of authority.
Thank you so much, Lauren. Some of the feedback has been just how thankful everyone is that this presentation happened, how thorough it is, how much they learned from it, both from Lauren's presentation and from Maggie's presentation. And I have a question for Jen. I'm a caregiver, and I'm wondering if I can submit this for training hours. If so, how would I go about doing that?
Yes, we have a certificate for everyone who attends today. And Lily, will this certificate be sent out to everyone, or should they send an email to me for the certificate?
They can send an email to you if they need it sooner, if you don't mind sharing your email.
Not at all. My email is jrexroad@caregivers.org, or you can type in info, INFO, @caregivers.org.
Thank you. It has really been a pleasure for me to be here today and to bring you all together. I'm an analyst at the California Department of Social Services, and I've also been both a kinship parent and a foster parent myself. The information shared today, some of this I wish I had known when I had become a kinship parent and when I had been a resource parent. And I'm just incredibly feeling gratitude towards advocates, towards Think of Us and California Alliance of Caregivers for sharing your time, your resources, your information with all of us today. There are multiple people giving you a round of applause in the comments. Thank you, everyone who's joined, whether you're a caregiver or you're somebody who supports a caregiver or family. We're really appreciative to have you here. I'd like to end with answering a final question, which is, how can I find out about other webinars? Everyone who attended today will get a follow-up email with resources from today's webinar. And additionally, when we host future webinars, you will get an announcement sent to you. Thank you all so much for being here today. It's really been a pleasure, and I just wanted to give you all a round of applause. Thank you, everyone. Have a wonderful rest of your afternoon and evening. And if you have other questions, feel free to reach out to us. Bye-bye.